Please sit down. What is the case? Call the case.
State versus Peace Kumar.
Who's the public prosecutor?
Me and the counsel. May I please proceed? So it's a case between Satish and Kamlesh. Kamlesh was married to Satish on 1st July 2009. So after the marriage, she was being brutally harassed and tortured by her husband and his father, her father-in-law. And ma'am, after the lapse of some time, she registered an FIR number 51 on 1st November 2015 at Thana number 7, Police Division number 7. And ma'am, they were demanding unlawful demands of rupees 5 lakhs from Kamlesh.
Somewhat loudly.
Yes, sir. They were demanding unlawful demands of rupees 5 lakh from Kamlesh. Satish wanted to buy a car out of that. And ma'am, later on that FIR was quashed by the High Court for the grounds that Satish gave in writing that he will never repeat the offence again. The matter was compromised. My co-counsel would like to proceed further.
Your Honor, the FIR had been registered again on 3rd July 2016 when the deceased Kamlesh committed suicide, and the police conducted the investigation and presented the case before the court of JMIC. JMIC has brought the case before this court, and the session court has framed the charges under section 304B of IPC, and during the investigation, the police came to know that Kamlesh has wrote the letter to her father on 29th July 2016, soon before she committed suicide, that she has been beaten daily by his husband and father-in-law as they were demanding rupees 5 lakh as dowry. My counsel.
Your Honor, if you look at the series of events that took place, from the beginning she was being subject to cruelty by her in-laws, and the demand of dowry itself shows that she was being threatened again by her in-laws again and again. So this is a case under 498A. So 498A IPC clearly explains cruelty as a willful conduct which can drive a woman to commit suicide. So she committed suicide under the pressure and influence of her in-laws for the demand of dowry. Satish and his father was very aggressive in approach towards her daughter-in-law. So 498A, they both should be moved under 498A.
Sir, moreover, in this case, it has been proven by the letter that there were persistent and again demands of dowry being made by the in-laws from the deceased girl, and it can also be proved by before compromise which was brought between them by themselves, and it was done before the court, in which an earlier FIR on the same basis of cruelty was compromised. And even after that, you can see the conduct of the parties, that they were not law-abiding people, and they were persistent in doing such kind of activities against the girl, and due to that, there was a fateful death of the so-called girl. And sir, the case is such that it should be brought under section 304B of the IPC, and they should be charged under it. And we are requesting the court that the accused father-in-law and the husband, they should be punished under 304B of IPC.
Was the death caused within 7 years of marriage?
Sir, the thing is, the death has been caused only like after the span only of 2 or 3 days, which can be relaxed in this circumstance, sir, because seeing the offense, and they have just used that time period in this case to come under a lesser part, that they were persistent in doing it. That girl, she also committed a suicide. By just fixing to the time period, we should not give away the right of the deceased person to get a good justice against the so-called accused, because they have been doing such activities which they had written to the court earlier that they will not do it. And still after writing it down to the court, it has shown their conduct that they were very, they were not responsible, and they were having no regards to the law and the rules. And sir, due to that thing, the girl, she has committed suicide.
We can say they were very resistant and hostile from the very beginning. Even after registering FIR, they were not willing to change their attitude.
Sir, may I proceed with the case? Sir, as the prosecution stated, that Satish and Kamlesh married on 1st of July 2009 and they were living happily in their house at Jalandhar Phase 1. Your Honor, my clients, the Satish belongs to a very well-off family. He is a very intelligent or hard-working boy. He has done his MBA from England and he is working as a CEO in a very reputed company. Moreover, father of a Satish, he is a paralytic patient and he is bedridden from the last 10 years. Satish has employed a caretaker for his care. Now the next question is, sir, no doubt we have not led any defense evidence, but the prosecution admitted all the facts in their cross-examination. They have admitted that they have visited her daughter-in-law's house several times before or after the marriage. And they were living happily after marriage. Her daughter were living happily after the marriage in her in-laws' house. Moreover, there was no torture to her from her in-laws. Next question is, they have admitted that the Satish father is bedridden from the last 10 years. Now I request my co-counsel to proceed.
May I proceed with this? Ma'am, the next question is to be considered is that whether the Kamlesh was subjected to cruelty or any demand of dowry was raised by the Satish family or not. Ma'am, as my learned counsel has stated that Satish is the employee, he is a CEO of a reputed company, he is a respectable person of his area, and he is having a handsome salary for fulfilling his livelihoods and his daily routines. He is already having a car of rupees 25 lakh, that is Fortuner. So why will he demand rupees 5 lakh from the Kamlesh family for purchasing another car? Moreover, ma'am, the deceased Kamlesh was not of a good mental condition. She was depressed. Because of that, she committed. She has earlier attempted to commit the suicide. And ma'am, the basic fact behind the story. Is this mentioned anywhere in the facts that she tried to commit suicide earlier?
Yes, it is not mentioned in the facts, but when she was admitted to the hospital on 1st November 2015, it was not the case of harassment. It was her first attempt to commit the suicide at that time.
But her husband and father-in-law themselves gave in writing that they will not repeat such behavior again.
They gave in writing, ma'am, but
Because ma'am, they want to lead a happy family life, or the Kamlesh husband is well aware about the mental condition of his wife, so he wanted to compromise the matter, and she already started her treatment from the psychiatrist, which is on record. So that's why they compromise the matter to lead a happy family
Sir,
life.
may I,
ma'am,
if you allow me?
Let defense counsel complete.
Kamlesh was unable to conceive the baby, and he is unable for the progression of the children. That's why she remained depressed all the time, and she has attempted to commit the suicide. That's the fact behind the suicide, ma'am. Now my fellow counsel will continue.
Now when Kamlesh committed suicide and Satish cremated her, and the father of the Kamlesh were also present at the funeral ceremony, and he has not objected anything. If he has received any letter prior to her death, why he has not objected at that time, at the time of the cremation of the Kamlesh? Actually, the envelope of the letter was not presented in the police challan because the letter was not even dated, and the envelope of the letter, which was written by someone else, that is why the letter was not presented in the police challan. And the father of the Kamlesh has also admitted in the cross examination that her daughter was really fed up from her life, and she has already tried to commit suicide. And her father is already admitted this fact that her daughter-in-law, her daughter, has never made any complaint to her father or to anyone else after the compromising of matter. How suddenly she can commit a suicide on the basis of that she was harassed by them. And the next question is that that they have demanded the dowry of 5 lakh rupees. Even the RC of the car is on record that they have already a car which was bought by Satish before his marriage. So there was no harassment, there was no demand of dowry, and moreover, the statement of the cross examination is on record, which was admitted by her father, and there was no harassment. Now I request my co-counsel to proceed.
Your Honor, may I proceed? Your Honor, it is my humble request to the court that my client is innocent person and he is falsely implicated in this case. Moreover, Satish's father, who is bedridden, how he can harass the deceased. So we are praying for the court that acquittal accused.
Sir, the defense is saying it is totally fabricated and false. They are all dodging with the facts and misleading the court. Sir, the earlier FIR, it completely states that there was a demand of dowry which they have agreed before the court at the time of compromise that they will not do such kind of activities. So we cannot get away with the fact that they were a very rich person. If they were an affluent person at that time, they could have not compromised the case at that time. They should have proceed with the case. Why are they compromising with the case and giving in the handwriting before the court that they will not do such kind of activities? Even sir, looking at the situation, that the girl was very beautiful at that time. They never, at the time of marriage, they never wanted anything. But after the marriage, even being rich, they started asking and tormenting the girl on the facts that your parents haven't given us anything and they should at least give something which is respectable to the family. And sir, those things are very true. They were very traumatized to the girl, and the girl, due to those things, she was forced to take such a hardened step against her life that she has committed a suicide. So sir, these criminals kind of people, though they are very rich, they should not be led away with those kind of facts which the defense is giving before the court.
Was she forced to commit suicide?
Sir, yes, by the circumstances which they have made before the girl. Because sir, the girl, when she comes to another house, she is all alone. When she doesn't have any person who can take care of her around with in the family, those circumstances are very tormentous. And one cannot live in such kind of, a human being is a civilized animal and it needs a society to live around. He cannot live like a saint, or he cannot live alone unless until he has attained a different kind of mental setup. But in this situation, the girl was very young and she has just started with her marriage life, and she was having much expectations in her life to lead a happy life, which by the activities of the accused has deprived her to have a better life, and because of that she has committed suicide. And moreover sir, if the defense is saying that this girl, she was having any kind of mental illness, before marriage also they should have gone through that, because they could have lived around, and even after that they could have even filed a divorce petition or something on that ground. They want to have a divorce, but sir, there is nothing on the record. And moreover, the only thing which has been brought before the court is the letter which has been proven, and the earlier FIR which was quashed, in which it is being proved before the court that is a case of clear cruelty and a case of death, which takes the case to fall under section 304B of IPC.
Names of accused are clearly mentioned in the letter, ma'am.
But actually, ma'am, this letter was written prior to her death, when earlier she has tried to commit the suicide. This letter was written by her, and after the cremation of the Kamlesh, her father received the letter, and then he lodged an FIR. When on the time of the cremation, why her father has not objected this thing?
Sir, at the time of cremation, a father who has lost a son or a daughter, he or she is not in a situation to make a ruckus over the dead body of the deceased. And at that time, a person cannot be so much in that kind of act that he should, because he has got such a big loss in his life. One cannot be so much calculative at that time. So this thing should not be in consideration before the court. What should be considered is the facts which already are before the court, and the court should make its opinion on those facts only, and it should not be misleaded or misguided by whatever the defense is saying.
But her father itself admitted in the cross-examination that her daughter was really fed up from her life. That is why
She is all fed up that she is.
Because
No,
she is
because
not
she
able
was
to
having
have
no
a
child.
One by one. Yes, please, what you want to say?
because she was having no child from the last 7 years of her marriage. That is why she was really fed up from her life, and she was many times tried to commit the suicide. And after the compromising of the matter and before her death, she has never made any complaint to her father or to the police that she was even once harassed by her husband or by her father-in-law. So suddenly she has committed suicide, and they are saying that she has committed suicide because she was abducted by her
Sir,
husband.
there has never been an FIR of an attempt to suicide lodged against the girl. It has never been brought before any police officer in the local jurisdiction that so and so girl has tried to commit a suicide. And moreover, sir, if it was so, it was a clear ground to get a divorce. Nobody will like to live with a girl who is mentally upset at that regard that she can commit a suicide.
But ma'am,
So
if
They are alleging that she was not mentally stable mentally. But what was the reason behind that depression? Let us assume that she was depressed. The attitude of in-laws drove her into depression. That was the main reason. The repetitive demands of dowry, that was the reason she was depressed from her life. As such, why she would be fed up from her life? Moreover, all of these facts are more of a fabricated, manipulated facts. They are just, these are the
Whose
facts.
husband is earning more than 25 lakh rupees, they are saying. Who is very well settled. Why a wife will commit suicide only on the grounds that she was mentally
There must be a
unstable?
reason
There
behind
must
a
be reason.
depression.
They were
Depression
meeting
as such,
regularly.
she can't
What
be
will
They
you
don't
want to
have
say on
clearly.
this point?
as the prosecution is establishing his case on the piece of paper which is even not dated. And if the letter was received by her father prior to her death, why her father has not lodged an FIR? Why her father has not communicated to her daughter?
What you want to say?
Sir, even a father is always willing to get her daughter a house made rather than destroyed. So, due to that reason, the father, he has never approached any police station. But before that, they have tried an effort that they got an FIR earlier, dated number 51, on date 1/11/2015, in which they have clearly written that she was being tormented and tortured for the demand of dowry, and a FIR in cruelty was registered under section 498A against the father-in-law and husband. And the father of the girl, she was told by the father of the guy that they will take care of the girl in due regards with her everything. But sir, such things were not done. The father, he received the letter, he read the letter, and even at that time, he made a contact with the parents, and at that time the parents told them that we are settling down the matter, it is some internal matter, you should not come inside. But sir, on the fateful day, even the father was not knowing that the girl is going to take such a step. So sir, the father is not at any kind of mistake, and this benefit should not be given to the defense, and the case should be brought, and the punishment should be given under 304B of the IPC.
Last words from the defense.
Sir, as the prosecution stated that the father of the boy made commitment that he will take care of the girl. The father of the boy is a paralytic patient. He is bedridden. He is not able to speak, or moreover, he is not able to do his daily routine. How he can make any type of commitment with the parents of the girl?
Sir, it is
Or
also
the parents
false
of the girl
that
know aware about all these facts before the marriage. They are well aware about all these facts before the marriage.
that the
Sir,
father.
if the girl is subjected to the cruelty or the harassment from the last 7 years of the marriage, so why she compromise the matter on the very first stage of the case?
But if the father was a paralytic patient, how did he wrote a letter or a paper stating that they will not repeat such kind of behavior again?
They have not written anything.
Sir, it was done before the court.
They have not written
The
anything.
compromise is before the court.
The matter is only stated by the Satish, because he is the only male member who is able to do the work of the family, or he wanted to live a peaceful, happy married life. So that's why, or moreover, he know the mental condition of his wife. So he just to compromise the matter to finish the matter.
You want to say something?
Yes, sir, our request before the court is that the accused, he should be convicted under 304B of the IPC. There is no way, it is a very clear case of dowry death, and the defense, by misleading the court by giving whatever they are saying, the court should give due regards to the facts of the case only, which is brought and proven before the court. The court should not go beyond those things, because they all are misleading and they are all false.
But the death was caused after 7 years,
Sir,
and we
though
should
the-
go according to the provisions of
Sir,
law.
though the death was caused after 7 years, but the time period of 7 years, they should not be very much fixed. Sir, the court should be relaxed in giving, because the death is just 3-4 days after the death of 7 years time, and the court, by seeing the heinousness of the offense, should give a precedent before the people that the intent of the legislature is not to make the accused go away by taking a help of a time period which has been mentioned in the code. So the request is, sir, they should be brought into 304B of IPC, and they should be punished as given in it.
Sir, all the facts are admitted by the prosecution itself, which is on record.
And
So-
the letter
was-
was,
the
the
letter
letter
was
was even not
examination.
dated. Letter was even not dated.
So it is my humble request to the court that my clients are innocent and they have falsely implicated in this case.
Please write. After hearing both the parties and on the basis of evidence on record, this court is of the view that in the present case, charges were framed under section 304B of IPC, which involves following ingredients. Death of the woman must be caused by burns or by bodily injury or otherwise than under normal circumstances, and it must be within 7 years of marriage, and soon before her death she must be subjected to cruelty or harassment by her husband or any relative of the husband, and such cruelty should be in relation with the demand for dowry. But in the present case, it is clear that death was caused after the lapse of 7 years of marriage, but it was an unnatural death, and strict provisions of law are to be followed. Further, on the basis of evidence and arguments, it is proved that deceased was being subjected to cruelty by her husband and her father-in-law before her death, and such harassment or cruelty was with a view to force her and her parents to fulfill their unlawful demand for a car, and such cruel conduct on their part abetted the deceased to commit suicide. Therefore, all the ingredients of section 498A and section 306 of IPC are fulfilled, and the court holds both the accused persons guilty of the offences under said sections. The accused persons are therefore convicted under section 306 read with section 498A of IPC. The court will hear the accused on quantum of sentence on 13th Feb 2018. The court is adjourned.